Hello, welcome to the webinar of the Ottawa Forum in Israel-Palestine. My name is Peter Larson. I'm the chair. I'm broadcasting here from Ottawa on ceded Algonquin territory here in Ottawa, Canada. And I'm thrilled to have David Kattenburg with me. David um, is a journalist based in Netherlands, and I'm thrilled that he's able to spend some time with us today to talk a little bit about the International Criminal Court and what's happening, particularly around the accusations against Mr. Netanyahu and against Mr. Gallant. David, thank you very much for spending some time with us today.
Peter, it is a pleasure, absolute pleasure. Greetings to everybody from the Netherlands.
Speaking of being from the Netherlands, you're not actually from the Netherlands, so why are you there?
Well, my father, the Kattenburgs are Dutch. Kattenburg is a district on an island just east of Central train station in Amsterdam. If you're ever there, you should check it out. And my father was a Dutchman, Fred Kattenburg, and his whole family was Dutch. His mother's side was German. His father's side was all Dutch, and it's always been my fantasy to live in the Netherlands. And here I am, living out my fantasy.
Well, good for you. Now we're going to proceed today. I will be having a nice conversation with David about what's going on. I just tell for everybody, if you have questions, please put them in the Q&A or in the chat. My colleague Grafton Ross, who is the vice chair of the Ottawa Forum in Israel-Palestine, will be paying attention to what's going on in the chat. David and I might not as we're talking to each other. Already, if you'll see in the chat window, we have David's email address, a link to an article he wrote recently in Mondoweiss magazine about what's going on at the ICC, although that now is 4 weeks old, so he'll be giving us a more update today. And also a link to the Green Planet Monitor, which is his website. So there will be rich information available in the webinar. But I'm going to turn to David. David, you live. Hull is not a very place. You don't live in The Hague, but The Hague is nearby. What's going on at the International Criminal Court now? How are things unfolding?
Well, it's a good question. It's all fascinating. I'm about 45 minutes away by train from the International Criminal Court in Den Haag in The Hague. And everybody's aware that criminal arrest warrants have been issued against Benjamin Netanyahu, Israeli Prime Minister, and his former War Minister, Yoav Gallant, as well as against the last surviving Hamas leader, Mohammed Deif. Those arrest warrants have been were issued by the pretrial chamber one, the first pretrial chamber of the International Criminal Court on November 21st in response to a May 20th application for arrest warrants from Chief Prosecutor Karim Khan.
So there was a long period there, David, where Karim Khan brought out this charge, and it wasn't clear whether the court was going to go forward or not another 4 or 5 months before they finally landed on it and say, yes, we're going to go after these guys. Is that right?
Well, it is, and that's an interesting question. It's a good question because Karim Khan submitted his request for arrest warrants on May 20th, and they could have been secret. They could have been, according to the Rome Statute provisions, Karim Khan could have requested the pretrial chamber to issue arrest warrants secretly, like in confidence, because it was an ex parte decision, meaning there's just one party to this request, Karim Khan. It was an ex parte request to the pretrial chamber. He could have done it in secret, but he made it publicly known on May 20th. He announced it, which precipitated a sequence of events, which is relatively unusual with the International Criminal Court, that suddenly everybody and their grandmother wanted to submit amicus briefs, and the UK submitted a request to the pretrial chamber to submit an amicus brief on this matter. And it was unusual, and the pretrial chamber said, sure, go ahead. And then they said, oh, anybody else who wants to issue an amicus brief, you go ahead too. So the pretrial chamber received like 70, over 70 amicus briefs in the spring and summer of just this past spring and summer. And
Now,
the UK, by the way,
Dave, when you say amicus brief, that sounds like friendly, but it doesn't necessarily mean it's in
oh, briefs
agreement
to the
with.
court. It's a
Yeah,
friend. Amicus
yeah,
brief is a friend of the court.
right.
It's somebody who's not a direct party, but is submitting the information to assist the court. It's
But it could have been on either side.
oh yeah, for
Yeah,
sure.
yeah, yeah,
Amicus briefs,
yeah,
sure.
yeah.
But the UK withdrew. UK said, "Oh, we're not going to submit our amicus brief. We've decided not to do it." Right? But then 70 more went ahead and did it. This happened in the spring and summer of 2024. So not a lot of people know about this. I've been following this, and a little more than half were saying go ahead with the arrest warrants, and a little bit fewer than half said, no, don't do it, like Lindsey
Uh-huh.
Graham and the U.S. government and the Canadian Jewish Students Association, truth be known. Um, and then after having received all those amicus briefs, this really delayed the process. But Kareem Khan submitted his request for arrest warrants in May, and the court ruled in November. So it wasn't all that long. Um, it was 6 months for it to rule and issuing the arrest warrants. But keep in mind, there are all these amicus briefs that have been submitted that are still on the record. So this is going to come up. Their arguments are going to come up. They've not been just swept away. They're out there. Yes, issue arrest warrants. No, don't issue arrest warrants. It's totally outrageous. And so on November 21st, the pretrial chamber one issued arrest warrants against Netanyahu and Gallant, which everybody talked about in the media. But what the pretrial chamber also did was dismiss a couple of challenges from Israel, which, if you look at these challenges, it's kind of getting down into a little bit into the weeds, and it's kind of minutiae of the Rome Statute and all this stuff. But if you look at them at their core, each of these challenges was really interesting. And the chamber's response to the challenges, and the chamber threw out both the challenges, and Israel is now appealing. That's the bottom line. Israel is now appealing this to the appeals chamber. The pretrial chamber one threw them both out. And the first was, I'm going to try to be quick. The first was, I'm going to close my email because it's pinging here. The first was that Kareem Khan should have issued another notification, another Article 18 notification. Now, when a prosecutor launches into an investigation, they send out a notification, an Article 18 notification to parties telling them, if you want to challenge this application, which Fatou Bensouda launched her process back in 2021. If you want to challenge this situation in Palestine, do so based on admissibility or jurisdiction or whatever. But you've got a response to the notification. And back then in 2021, Israel didn't do it. I'll get back to this in a minute. I mean, their lawyers are sloppy. They didn't do it adequately. They missed the mark. And then again, they did it in 2024. They wanted to respond. They wanted the court, Kareem Khan, to issue another notification.
David,
Yes.
I'm getting a little bit lost here. I mean, the essence of what I hear you saying is that Israel found a technical reason to be opposed to this finding. Is that right?
Yeah, these are technical reasons, but they're interesting. I mean, the first was that the court's got to provide notification, and that in Bensouda's case, Bensouda provided notification back in 2021 pertaining to the protective edge and the massacre of the Great March of Return folks and the settlement enterprise. But of course, October 7th hadn't happened yet. And Israel didn't respond to that notification. And so now in 2024, Karim Khan launches prosecutions based on October 7th and post October 7th. And Israel is saying this is a totally new situation. It's a completely new situation, which gets to the argument of Israel and its advocates that it all began on October 7th. There's nothing that preceded October
Mm,
7th.
mm.
So what preceded October 7th was a totally different situation. Up to post October 7th is brand new, which is, of course, historically false. And the pretrial chamber on November 21st said, no, the two situations are the same. So this is fascinating stuff to go into. But for
Mhm.
those who are listening to Israel saying, "Oh, it all began on October 7th," there were no precedents.
Right.
Like Antony Blinken saying it all began on October 7th. The International Criminal Court doesn't think so.
Didn't buy that. Okay. Mm.
Didn't buy that. Now, the second thing is jurisdiction, which is really interesting. That Israel has been arguing that you don't have jurisdiction over us because we're not a signatory to the Rome Statute, and we don't accept their jurisdiction.
And
So you
The
can't.
Rome statute,
We're not. We're not signatories to the Rome
and the
Statute, so you can't.
Rome statute is the document that created the ICC. Is that right?
Correct. We'll
Yeah.
get to
Yeah.
that in a
Okay.
moment.
Yeah.
So we're not signatories to the Rome Statute. We've not signed on, so you can't prosecute our citizens. You don't have jurisdiction. Well, guess what? Back in 2020, Fatou Bensouda asked the pretrial chamber at that time, "Do we have jurisdiction?" And the pretrial chamber said yes, because Palestine is a state. Is a state party of the state of Palestine, which really pissed off the United States and Israel no end. That's what the pretrial chamber ruled in 2021, that Israel is a state party for the purposes of the Rome Statute, so they can refer situations. And their territory, now this is what really got Israel going, their territory is the West Bank, including East Jerusalem and Gaza. And so it's the jurisdiction, courts got jurisdiction over this. So Israel just, in the wake of the November 21st arrest warrants, before the arrest warrants were issued, said you don't have jurisdiction. And the pretrial chamber said, A, you can't make such a claim before we've issued arrest warrants, which they hadn't at that point. And secondly, it's all been decided. It's res judicata. The pretrial chamber ruled back in 2021 that the courts got jurisdiction. So go away. I just want to say one point here, and then you can continue with your questioning, Peter, that what this raises to me, what this points out to me, and people say, well, this is the weeds. Why does this matter? The first is that Israel has never taken the International Criminal Court seriously. Certainly not back in 2020, not in 2021. And they're not taking it seriously. They're beginning to, but they still haven't. Their lawyering is sloppy. And my colleague and friend and comrade Dimitri Lascaris, I want him to hear this. Israeli lawyering is sloppy and mishandled, and they've got a weak understanding of the Rome Statute. And Karim Khan just beats them out no hand. Like Karim Khan totally outguns the Israelis, um, and so on and so on. And so the pretrial chamber, now the appeal. So Israel has appealed to the appeals chamber. So this is now they got rejected two times over by the pretrial chamber number one, and the arrest warrants were issued. So they've taken it now to the appeals chamber. And Karim Khan just responded to Israel's appeal to the appeals chamber just on Monday. On Monday, people can check this out at the ICC website. And now the appeals chamber of the International Criminal Court is going to rule. And if they rule, and Israel is asking for the arrest warrants to be suspended, annul the arrest warrants. Well, that's not going to happen. And I think, and I've been informed by people, told by individuals who are in the know that the appeals chamber is going to side with the pretrial chamber.
My
And by
understand.
the way, the president of the appeals chamber is the president of the International Criminal Court. who just this past November was talking to the Assembly of State Parties about how the Rome Statute is under threat.
David, my understanding is that Israelis have also been attacking from another angle. They've actually been trying to undermine the credibility of Karim Khan as a person. There have been a number of charges that were allegations that were brought forward and so on. It's a bit of a dirty tricks kind of operation.
Well, I'm not sure if it's a dirty tricks operation, but yeah, I mean, there have been allegations were made against Karim Khan that he had behaved misappropriately to a woman, a colleague, a member of his staff, and he denies it. And it was going to be investigated by the International Criminal Court's the entity within the ICC that deals with conflicts like this, but there were charges of conflicts of interest, and so an independent investigation has been launched, totally third-party investigation of the allegations made against Khan, and that's where it stands.
Okay.
I've not heard anything about this. There were charges or thoughts that maybe this was a dirty tricks operation, and my sense is that Israel took advantage of it or tried to profit from it, but it was something that's, legitimate and authentic. And between you and me and everybody else on this call, you know, I've I have every reason to believe that Karim Khan, like lots of other men, are potentially, exposed to situations like this.
Right.
See
Okay.
what happens. No
Um,
connection. No
okay.
connection to the current proceedings.
Right. David, just for those of us who aren't clear, remind us quickly what the ICC does and when it was created and why it's different from the ICJ. Those are two different institutions, both in The Hague, as I understand.
Correct. Across town from each other. I've been to both. The International Court of Justice is the International Court of Justice seated at the Peace Palace, just kind of central to The Hague, is one of the five institutions of the United Nations system. There's the UN General Assembly, the UN Security Council, the Economic and Social Council, the Secretariat of the United Nations, and the International Court of Justice, which is the supreme judicial body of the United Nations and of the international system. 15 justices elected. It's the supreme judicial body of the United Nations, established under the UN Charter in 1945. The International Criminal Court across town was created under the auspices of the Rome Statute, which was enacted in the year 2000. No, sorry, in the year 1998, but it came into effect in July of 2002. The Rome Statute, and oh dear, here we go. Sorry, and here's the Rome Statute of the International Criminal Court and the rules and regulations, which you can download. It's a great read. I had this printed out. So this is the Rome Statute, which created the International Criminal Court, which came into being in 2002. So the International Criminal Court, its job is to, this is a quote, investigate and where warranted, try individuals charged with the gravest crimes of concern to international community, namely genocide, war crimes, crimes against humanity, and crimes of aggression. And they're all listed in Article 5 of the Rome Statute, which you should all read. So the International Criminal Court is kind of like almost like a follow-on or a child of the Nuremberg Tribunal that tried the Nazis and the Japanese, I guess, yeah. And yeah, and so
Okay.
but the important thing is that the International Criminal Court tries individuals. It tries individuals. It doesn't
Right.
try states. It tries individuals. The International Court of Justice adjudicates disputes between states.
Okay. So for those people who are arguing that Biden and Blinken and Jake Sullivan should be are war criminals, the appropriate place to bring them would be to try to bring them to the National Criminal Court if they were the Nuremberg kind of follow-up to take place. Is that right?
Yeah, that would be the place to bring them.
Yeah. Um, um, Erwin Kotler, a Canadian human rights advocate who you probably know about, has made a big deal about the fact that he thinks that the ICC should have jurisdiction here, but that it wouldn't apply in the case of Israel because of the ICC's principle of complementarity. And as you can help me through this, but basically his thesis is that ICC only applies in countries and situations where there isn't already an existing competent juridical basis. And therefore, he says because Israel has such a thing, this should not apply to them. Am I right about the notion of complementarity? And how
Yeah,
does that?
complementarity is this notion in international criminal justice that if a state is capable and willing to try alleged crimes itself in a serious, credible manner, then it should be deferred to do so. In the case of the International Criminal Court, this is precisely the purpose of notifications, that when an investigation is launched, as Fatou Bensouda launched her investigation, preliminary investigation. Well, I guess this would have been her full-scale investigation into Israel, into the situation in Palestine in March of 2021. She sent out a notification to all the state parties and to Israel, which wasn't a state party, giving Israel the chance to to say to exercise its complementarity rights, and that Israel has a robust, incredibly robust judicial system, fearing fearing nothing and favoring no one, and is fully capable of trying the soldiers who massacred people in the March of Great Return. There were several hundreds who were killed, and in fact, Israel is prosecuting them now, and it's investigating their crime. No, no, of course it's not. So
Well, that's the
Israel
Israeli
didn't.
argument.
That would have been the Israeli
Yeah.
argument. It is. We're capable and willing to do so. But in 2021, Israel didn't do it. They didn't actually they were late in responding to Fatou Bensouda's notification, and they didn't really provide evidence that they were trying people. And it was exactly the same thing in 2024 when Israel filed its belated request to, 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 for a new notification because the situation's changed. So we could argue that its robust system is actually bringing Netanyahu and Gallant and others to justice for alleged crimes. It's nonsensical. And Karim Khan said, you should read it, these documents. He said, A, they were late in responding. B, they didn't cite Article 18.2. C, on repeated requests, they didn't provide detailed information about complementarity. So it's just,
Okay.
there you go. That's what complementarity is
Yeah.
all about. That if a country like the United States is capable of bringing its soldiers to justice for war crimes in Afghanistan, then the International Criminal Court's got no, it should defer to the United States. That's another story. But as far as deferring to Israel, Karim Khan's been quite clear in his writing that it's, I'm paraphrasing him, that it's a bit of a joke. Israel's not putting anyone on trial,
Right. Okay.
or
Um,
much less investigating them.
I remind people that you can put questions in the chat box or put them in the Q&A, or in a few minutes, I'll ask those who are interested to raise their hand if they want to ask a question directly of David. But I have a couple more questions I wanted to just go with him before we do open it up to everybody. David, what's Canada's role in the ICC?
Well, Canada, Canada acceded to the signed the Rome Statute of the International Criminal Court in 1998, right? Shortly after it was enacted, the Rome Statute, Canada signed onto it, and it acceded to the Rome Statute in July of 2002. I think I've got that right. But most importantly, that Canada has incorporated the Rome Statute into into its own domestic legislation in the form of the Crimes Against Humanity and War Crimes Act, which was enacted in that was enacted in the year 2000. The Crimes Against Humanity and War Crimes Act, which actually embodies within which the Rome Statute is embedded. And if you go to the, I can provide this link, or you guys can find it. Crimes Against Humanity and War Crimes Act. Pull it up. It's a PDF. And within it, you'll see that the Rome Statute is embedded. So Canada is a party to the Rome Statute. And so therefore, it is obliged to honor, to execute arrest warrants against Benjamin Netanyahu and Golan, should they come visit, which I doubt they will. But even more than that, actually, Canada is obliged as a member, as a state party of the Rome Statute, a member of the Assembly of State Parties, Canada is obliged not to even engage in conversation with Netanyahu. This is in an Assembly of State Parties resolution, because you've got the Rome Statute of the ICC, but you've also got the Assembly of 125 state parties, the most recent of which was Ukraine. Just this month is the 125th party to the Rome Statute. And the Assembly of State Parties resolved back in 2017 that state parties shouldn't even engage in conversation with somebody who's facing an arrest warrant. So if Poilievre were to go to Israel, the new Prime Minister Poilievre was to go to Israel, he would have to refrain from talking to Benjamin Netanyahu.
Interesting. Does the court have its own police, its own prisons? How does
They
the
don't.
court?
The ICC, of course, I mean, it consists of, there's the prosecutor's office, and then there are the various tribunals, which are courts, pretrial chamber 1, pretrial chamber 2. This is the French civic system of law, where you've got pretrial chambers and trial chambers and appeal chambers, and the ICC's got all of them. They've got a bunch of different trial chambers, and then they've got the prosecutor's office, and then they've got the registry, and then they've got that's it. They don't have a police force. They depend entirely on state parties, those 125 state parties, to execute arrest warrants, to cooperate with the court, as it said, seizing, arresting, surrendering people against whom arrest warrants have been issued. And this is a big issue, most recently because Poland, President Andrzej Duda of Poland and Poland's Prime Minister, Mr. Tusk, have indicated that if any Israeli leader wants to attend Auschwitz, 80th commemoration of Auschwitz ceremonies in Oświęcim, Poland on January 27th, that's 10 days from now, January 27th in Oświęcim, Poland, 80th anniversary of the Auschwitz, and the Polish government, prime minister and president have said, apparently, any Israeli leader is welcome to come and we won't touch them. So
let me just clarify here. We have a situation where the
so
court.
that's where the rubber hits the road. See, the ICC doesn't have a police force. It depends entirely on governments like Poland, state parties like Poland, to arrest Netanyahu or Gallant if they show up on their territory, or the French, or the British, or the Canadians, or the Germans, and if they don't, what does the court count for? Because Putin visited Mongolia last year, and the Mongolians didn't arrest him. And Omar Bashir, The president of Sudan, who's got an arrest warrant on him, visited South Africa, and the South Africans didn't arrest him. So this is out there that if, state parties seem to be, I mean, they're sovereign states. They're free to just to thumb their noses to the ICC. But if they do, they're violating their duty under the Rome Statute.
So this seems to does that mean that the ICC is basically a paper tiger?
No, no, a good question. Because, I mean, this is just reality. What I'm relaying to you is reality. States are sovereign in the international, judicial legal order. And we've not talked about international law versus the rules-based order. But in the world today, the post-Westphalian order, countries are sovereign, right? Even under the pre-Westphalian order, they can do what they want. So they
Unless
can
somebody
ignore.
bigger doesn't like them.
Yeah, I mean, they can, countries can, but issuing arrest warrants against Netanyahu and Gallant and Dave is not going to be traveling. But the reality of this is that Benjamin Netanyahu, like if Sarah Netanyahu wants to go to Milan to do some shopping, she's going to have to go alone.
Right.
Because Benjamin Netanyahu, right, the Polish government can say, Tusk and Duda can say, you can come here if you want, we won't touch you. But that doesn't mean that a Polish judge in Warsaw, won't slap and, seize him. And Netanyahu knows that. And so he's not going to go to Auschwitz.
David, I remember a case some time ago. I don't know if this is germane or not, but Augusto Pinochet was in London, and the British government wasn't doing anything about it. Maybe he was shopping. I don't know what he was doing. And then a Spanish judge brought forward a case against him, and he had to hustle quickly back to Chile to not be put in the Husgau in London. Is that also an ICC case or not?
Well, I think that happened not under the ICC, but under universal jurisdiction, that
Right.
somebody knew that some Chilean activist or French activist knew that Pinochet was going to be in Spain, and they notified the Spanish judiciary and asked them to exercise universal jurisdiction, which is a little different.
Okay.
And an arrest warrant was issued, and the Spanish government interceded, and Pinochet escaped unscathed.
But in this case,
But
it
I
could
mean, we've got in mind, about you and I know, Peter, about the Hind Rajab Foundation.
might explain, say a word or two about that, David.
Hind Rajab was this
Yeah.
little girl, this sweet, gorgeous little girl who got hideously murdered by Israeli forces alone in a car. I'm sure you've all heard about it. Hind Rajab. She was like 6 years old, and a foundation, and there's no accountability, zero. And Israel denies it. Israel says, "Oh, we weren't anywhere near the scene." So this foundation's been established in Brussels called the Hind Rajab Foundation. Look it up, my friends. You should. I would recommend to you that you consider contributing to the Hind Rajab Foundation. And they're now tracking IDF soldiers and these young 19 and 20-year-old Tony looking Israeli boys and girls who are traveling abroad to Greece and Spain and Thailand and Brazil, and tracking them and triggering arrest warrants against them. And
And using the
so,
ICC, correct? They're bringing cases.
well, no, 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 because those guys don't have arrest warrants issued against them by the
But I think,
ICC.
David, I think they've petitioned the ICC to bring they brought
Yeah, the Hind
yeah,
Rajab
yeah,
Hind
yeah,
Rajab Foundation has provided
yeah.
the names of like 1,000 soldiers to the ICC. So you may be right. Um, but I mean, the bottom line is that the ICC, the arrest warrants, have a real and immediate impact, not only on Netanyahu and Gallant, but on a whole pack of just kind of lots of Israelis, lots of soldiers. It's interesting.
There was a
So
report
it's
of
not,
one.
it's not, it's not, I mean, they may never face justice. They may never be thrown into the little bed and breakfast Husgau, which we've not talked about in Scheveningen. like the prison that they've got. The ICC's got a prison in Scheveningen on the coast, and I was just describing it before this meeting to Peter, and that it's a this ICC prison is like a kind of a budget, highly pleasant, clean, proper, neat, functional, but budget hotel that you check into and check out 25 years later, or never, or never. And it's, God, if I had to live there, I'd live there. I'm joking, but you check it out. And the link is the link to the description of the ICC's prison facility is up there in the chat.
Back on the Hind regime for a minute, I remember there was a case a week or two ago. An Israeli soldier who had been Hind Rajab had gathered a dossier together on him where he'd done some atrocious acts. I don't know what they were specifically, but a charge was laid against him in Brazil. He was on holiday in Brazil and
And
he
he
had to
got
escape
out
Brazil, run away to
and
Argentina
escaped.
to not get arrested. So it's effective.
Yeah, and Israelis got him out. I mean, the trouble is that all these guys have posted like there's just mountains of incriminating evidence that they've posted on Facebook and Snapchat
Right.
and TikTok and
Okay, so listen, questions, Grafton, are there questions in the Q&A or people want to raise their hand if they want to ask a question directly of David? Please do so. I'll just keep on. Grafton, have you got something in the Q&A that we can start with?
Yes, I do. Sue Blackwell asks, why hasn't Karim Khan requested arrest warrants for Smotrich and Ben-Gvir? They're two cabinet ministers in the Netanyahu government. Why haven't they requested arrest warrants on the grounds of incitement to genocide? Might they still do so?
hello, Sue. Greetings from Breda. Um, well, I think that Karim Khan chose to request for arrest warrants against Netanyahu and Gallant because they were the lowest hanging fruit, the most obvious ones. And I think he did it to I mean, I'm not a lawyer, I'm not privy to information of this sort, but I think he did it to test the waters, because this is the first time that arrest warrants have ever been issued against a quote unquote Western democratic power, much less, you know, the United States is kind of conjoined twin, Israel USA, I call it. And so he was kind of testing the waters. Request arrest warrants against Netanyahu and Gallant first, and for the obvious crimes, not for genocide, because genocide's really hard to prove, but for the most obvious crimes, and his application was accepted. So I anticipate that, and others do, I think, that certainly once the appeals chamber upholds the pretrial chamber, if the appeals chamber largely upholds the pretrial chamber, throwing out Israel's appeals, then all bets are off. Like Karim Khan can add charges to his charge list against Netanyahu and Gallant, like genocide, and like the settlement enterprise, which was the core of Fatou Bensouda's issues, didn't figure at all in Karim Khan's. The settlement enterprise, it's the most obvious war crime under the Rome Statute. It violates 49(6) of the Fourth Geneva Convention. It's a war crime under the Rome Statute. Absolutely unquestionable. He's going to add those. And I anticipate that he'll apply for additional charges, arrest warrants against Ben-Gvir, against Smotrich, against Halevi, against the chief of staff. God, there's probably 6 or 7 of them that arrest warrants could be issued against.
Grafton, have you got any other questions there?
And I think
Yes,
it'll happen. I do think it's going to happen.
Yes, Stephen Chappell asks, what is the main difference between the rules-based international order and international law?
Ah, well, it's a good question, and it's This is Peter asked this question of me very synchronicitously, but just because days before Peter asked me, but by the way, I'm going to ask you this question. What's the difference between international law and the rules-based international order? I got this email from John Dugard, eminent South African Dutch jurist, former UN Special Rapporteur on the human rights situation in Palestine. John and I are in touch. John lives in Leiden or in The Hague, and he's just written an article which I'll put up in the chat entitled in the Leiden Journal of International Law, and the title is, it's an editorial, "The Choice Before Us: International Law or a Rules-Based International Order." So, I mean, to cut to the chase, this is a fascinating read, but international law is public international law. It's in the case of Israel's war on Gaza, it's the laws of war set forth in the Hague Conventions, the Hague Regulations of 1908, and the Geneva Conventions of 1949, the UN Charter, the Geneva Conventions and their additional protocols of 1977, the Genocide Convention of 1948, the Apartheid Convention of 1973, the International Covenants on Civil and Political Rights and Economic and Social and Cultural Rights of 1966. This is international law. This is the canon, and of course the UN Charter. This is international law. The rules-based international order, here at the very last paragraph of John Dugard, an international order founded on the UN Charter and international law as it has evolved since the end of the Second World War, is a sounder recipe for peace than an amorphous and discriminatory rules-based order. An amorphous and discriminatory rules-based order. Like the rules-based international order, it's an ad hoc construction of Western powers with the United States at the lead, Canada close behind, the European Union, based on self-interest, geopolitics, and it's a chimera. It's a chimera. And I want to very quickly illustrate this, that back in 2017, I took the Canadian Food Inspection Agency, the Government of Canada, court with Dimitri Lascaris leading the way over its false labeling of product of Israel wines, settlement wines, product of Israel. And we argued that the labeling of product of Israel settlement wines that were produced in settlements had violated the Fourth Geneva Convention, the UN Charter, the additional protocols as products of Israel was flagrantly in violation of international law. And Canada's response was, the Attorney General's response was, it's got no bearing on this case. International law has got no bearing on whether or not the Canadian Food Inspection Agency should label settlement wines as product of Israel or not. It's no relevance. At the same time, Canada was saying, vis-a-vis Huawei, the Huawei executive, remember her, Meng Xiao Wao, or whatever her name was. My apologies. The CEO of Huawei, who the United States wanted Canada to extradite to the United States. And Canada was, oh my God, it was wavering because it was under the three Michaels were being held in a prison in China, right? And Trudeau was talking about the rules-based international order. We've got to extradite this woman to the United States because the United States says that she broke their laws by dealing with Iran. And so we've got an extradition treaty with the United States So we've got to extradite her. That's the rules-based international order, which we respect. But in the end, of course, Canada sent the woman back to China, in return for which we got the three Michaels back. That was the rules-based international order. At the same time, Canada was saying, no, no, the Fourth Geneva Convention and Article 25 of the UN Charter has got nothing to do with whether or not how we label wines produced in illegal settlements that you say are illegal in the West Bank. So one is completely self-serving and hypocritical and amorphous and playing around gaming the system. That's the rules-based order. And the other side is international law.
So I'm struggling with this, and you can help me understand it here. What I think I hear you saying is that there are rules that are established by international law, but those who call for a rules-based international order are selective in their application of the rules. Is that right? Or are you saying something? Are there different rules set down in when the Americans or Trudeau talks about rules-based international order? Are they talking about rules A, B, and C, and the international laws are rules X, Y, and Z?
Well, it's interesting because at the end at the end of this article by John Dugard, he makes a point which is really interesting. He says he distinguishes the position of the Western countries on international law and the rules-based order versus the position of Russia and China about international law. And he says the West, this is John Dugard speaking, the West emphasizes democratic governance, human rights, environmentalism, and globalization. Russia and China emphasize the sovereign equality of states, non-intervention in the internal affairs of states, the settlement of disputes by mechanism to which states have consented, the immunity of states and their officials, and the condemnation of double standards in the treatment of states. And, this is a Sino-Russian approach that was spelled out in 2016. So there are competing views about the role of international law, quote unquote. Like, what should international law uphold or serve, right? Dominance, hegemony, or self-determination, sovereignty. It's complicated, but you've got this body of international law, which is it's the Fourth Geneva Convention, it's the Rome Statute, it's the law. And on the other hand, you've got this kind of amorphous system of constantly shifting parameters and rules that are self-serving and, cynically, deceitfully, mobilized in order to defend this or another position on our behalf and behalf of our allies. That's the rules-based international order.
Is there another, you mentioned China and Russia, is there another set of laws that are in the wings? I mean, is it if the rules and the laws that we're establishing now around the ICC and ICJ, if they turn out to be mostly without teeth, not saying they're not completely, but is there another set of laws that is being put forward or up for discussion, or is it the question is about the equal-handed application of the laws that have been agreed to? Or do you know? Maybe it's not a fair question.
It's a difficult question to answer. I mean, my inclination is to say that ultimately, if the law is to be upheld, to the extent that it can be upheld, it's the responsibility of people like us, to make it be upheld, if that's correct English, to make it upheld, to uphold it, to oblige our elected officials to uphold the law. Because, I mean, before laws, the laws slip under the surface of the waters, I think people's respect for the law sinks under the waters.
Mm.
It's our respect as individuals, informed, intelligent, conscientious people, to fight for the law the moment we stop doing that, it all sinks. And so, no, I mean, I think that the body of laws of all these laws, the UN Charter, they're great reading. I would advise and suggest that folks in their spare time, rather than going on Facebook, read the Rome Statute of the International Criminal Court or the Fourth Geneva Convention or the International uh, Universal Declaration of Human Rights. Read the Universal Declaration of Human Rights. It's just a declaration. It doesn't have the force of law.
Okay. Once again, anybody else with questions? Are there questions in the Q&A that we haven't addressed yet?
Not a question as such. Lawrence S. Cumming makes the observation regarding the Pinochet case. He notes that Pinochet was in fact holed up in London for quite a long time, and the Thatcher government kind of slow walked that and allowed him to return to Chile before he appeared in court.
Yeah, I think that's right. It was a Spanish judge that went after him, but physically he was in London. I think that's correct.
Susan Starkman, commenting on notes that both parties to a conflict must request the UN peacekeeping force. If they don't, we're forced to stand by and watch Israel and Russia slaughter people. Is there any way to stop this?
Could you repeat that?
According to Susan Starkman's understanding, both parties to a conflict must request the United Nations peacekeeping force. If they don't, we're forced to stand by and watch as Israel and Russia slaughter people. Is there any way to stop this?
Hi, Susan. I mean, I think to stop a conflict, both parties have to want to stop the conflict. Be it in, between Israelis and, I don't think this is a conflict between Israel and Palestinians, Israelis and Palestinians. It's it's a situation of oppression. But I mean, in order for it to end, so you can't expect the oppressed people to stop resisting or fighting. So it's complicated. But in a conflict, both sides have to acknowledge the humanity of the other side, I think. And the most powerful is the most incumbent on the most powerful to bend.
I'm going to ask Mervyn Russell to ask a question of David. Mervyn, can you hear me, Mervyn? You're muted. There you go.
Yeah. Okay. No, I want to add what I think is some correct information about the Pinochet business. In actual fact, lawyers did bring a case to the High Court in London, and the High Court was in actual fact prepared to act. And so Thatcher had to get him out as quickly as possible. And if I recall correctly, he was going to go to Spain, and Spain said, if you land here, we're going to act. So the British court, in fact, I think, was prepared to act, and Thatcher had to get him out. The second thing I think I'd like to contribute as far as the discussion between the international law and law-based order. I think law-based order simply means that states recognize the laws of other states that they are favorably inclined towards. That is a recognition of the international law-based order. What David has been talking about is, in actual fact, statutes which have been signed onto by a whole number of parties and therefore have a far more universal application than just the international law-based order. And would I be correct, David, in that?
Mervyn, it sounds like you know a lot more about this than I do.
Thank you for your contribution, Mervyn. That's good of you.
Thank you, Mervyn. Yeah. I'm just an amateur in all this. By the way, I got into all this as a result of, well, I mean, there are antecedents, which I won't go into. There are antecedents, but my first really true deep dive into international law was my my wine labeling case going back to 2017, for which, Dimitri Lascaris deserves to be carried around on a sedan chair for the rest of his life for having supported me in that endeavor. Totally pro bono. He was a complete hero.
Grafton, if you got one or two more, we're getting near the end of our time, but
Okay.
And by the way, on that topic, we won. Dimitri and I won at the Federal Court of Canada and at the appeals court, federal appeals court, that labeling settlement wines as product of Israel is unlawful. It's false. It's false. It's false. And so, in response to the Federal Court of Appeal, the Canadian Food Inspection Agency reconsidered its consideration, and it arrived at the conclusion that yes, product of Israel on settlement wines is false. And then it set out back 15 months ago, just at about the time when October 7th, 2023, interestingly enough, to plumb public opinion on how settlement wine should be labeled. And that's now through, it's finished. No, it was prior to that. And they've not come out with recommendations on how product of Israel, like settlement wine, should be labeled. And today, the province of Ontario, you will find Golan Heights wines produced on Syrian Golan Heights, now expanded by Israel, expanded territory, oil and gas exploration by Israel. That's what's the word for that? Stealing other people's property and growing wines and selling them in Canada, labeled product of Israel. Product of Israel. So those product of Israel wines are still being sold on Canadian store shelves, in spite of the fact that the Federal Court of Canada and the Appeals Court of Canada have ruled that it's false. What does that tell you about international law versus the rules-based international order? I mean, it tells me that the Canadian government really doesn't give a whit for international law. I mean, it does when it suits its interests, and when it doesn't suit its interests, it doesn't give a whit.
the example that always bothered me, and I'm sure many others, is this whole notion of responsibility to protect. On the one hand, we say that we're to protect people who are being badly treated elsewhere, but we are very selective. We're not rushing in to help protect the Palestinians in Gaza, for example. It's a very selective application of the principle, and I think it almost from the creation of the principle, it was no other way it could happen. It was only the countries with the ability to intervene will do so, and they'll do it when it serves their purpose. Crafton, you got one more question before we go?
And Egbert is saying that during the Pinochet case, Tony Blair was prime minister, not Thatcher anymore.
Well, little by little, we're getting to the
Okay.
truth here.
Yeah.
Tony Blair was pretty dreadful, pretty abysmal.
Bessa Whitmore asks if David could comment on the current ceasefire agreement and whether he thinks Israel and Hamas will actually comply with it.
Well, I think Hamas wants to comply with it, but Israel doesn't. Netanyahu doesn't, and it's already been undermined. If you're following the news at this hour, you'll know that in the last, I don't know, since the announcement of the ceasefire, Israel has killed, 78 people have been killed by U.S. bombs and missiles. There might have been a few German ones in there, and it's insisting Israel is that Hamas has violated, not actually not agreed to what everybody's saying it has agreed to. Israel is saying, Netanyahu is saying that Hamas has not agreed to what Donald Trump and Biden have both said Hamas has agreed to. All right. And it's obviously just gunning to to violate the ceasefire. So I'm pessimistic. I'm not sure the ceasefire, I hope it takes hold, but I'm sure that even if it officially takes hold on Sunday, Israel will be, violating it left and right. And Israel has no intention, Netanyahu has no intention of ending his war. And the question is, what position will Trump take?
I think that's right. It's a little early to tell, but one thing we can be sure of is that whether or not Israel um, signs an agreement, the Israeli intent, the Zionist intent to take over all of Palestine and to eliminate the Palestinians in the process will not go away. So it will be um, pursued by other means, and we're in for continued struggle for some time. Even though if there is a ceasefire, that's very good news for the people in Gaza.
Yeah,
A
there's
little
only
one.
one solution. There's only one solution. And that one solution is for the international community with the United States at the lead. The United States would have to, Israel USA would have to be at the lead. I refer to the United States as Israel USA, which is a kind of a conflict, a contradiction. Why would Israel USA be at the lead in taking such a position that I'm about to propose? But the position should be that Israel should get out of Gaza, right? The United Nations, the International Court of Justice's July 19th ruling on the illegality of Israel's occupation, entire occupation, ratified by the Assembly, the General Assembly, with Canada abstaining in whenever that was, October. And that further to that, the international community should order Israel to get out of Gaza and to make it happen,
And out of the
right?
West Bank. And out of
And
the
out
West
of
Bank.
the West Bank,
Yeah.
out of the West Bank,
Yeah.
international intervention force into Gaza and across the Allenby Bridge into the Jordan Valley and the West Bank, getting Israel out. And that's the only way it's going to be resolved. And I don't see that happening.
David, I'm going to wind up there. You've been very generous with your time. I'll just say to our audience that in a follow-up email, I will send you an email that includes a video of this presentation as well as some links to David's website. Uh, David is based in the Netherlands. He's happy to get contributions to his website. It's called the Green Planet Monitor. I also remind you that we at OFIP also have our handout because we have some ongoing expenses. So anybody who feels like making a minor contribution to our work can do so very easily by making an e-transfer to us, and that'll be in the follow-up email. I want to thank Grafton Ross, who's in the background, the Vice President and Head of Research for OFIP, who's been managing questions. Thanks to all of you who joined us today. And finally, thanks again to David for spending time with us and helping us understand this issue. All the best and have a great day.